Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss another judicial pronouncement by the Honorable Supreme Court of India, namely Chief Election Commissioner versus M.R. Vijay Bhaskar and others 2021 SCC Online SC 364. In this case, wide judgment dated 6th of May 2021, the court discussed the freedom of media to report oral hearings of the courts and the authority of a judge to conduct judicial proceedings. What the court predominantly did in this judgment was to reiterate the principles of open court, judicial restraint, and free press. Keeping this in mind, let us discuss the facts of the case. In this case, it was alleged that the Madras High Court, while hearing a matter in relation to maintenance of COVID protocols in polling booths in April 2021, had orally observed that the EC is the institution that is singularly responsible for the second wave of COVID-19 and that the EC should be put up for murder charges. The allegations against the Madras High Court were quite serious. I repeat the quote. The EC is the institution that is singularly responsible for the second wave of COVID-19 and that the EC should be put up for murder charges. These remarks were widely circulated in the media and the Election Commission sought a direction that the media may be allowed to report only the proceedings that are on record and not oral remarks. It was further prayed that the police may be restrained from registering any murder case in relation to the oral observations made by the Madras High Court. However, the Madras High Court did not consider grant of such relief and the EC approached the Supreme Court seeking relief that media reporting of only what forms a part of the judicial record before the Madras High Court and not the oral observations of the judges may be done. There was another relief that was sought by the Election Commission. It sought that no coercive action may be taken against it in respect of a criminal complaint lodged against it at Kolkata. Now let us understand the observations that were made by the Honorable Supreme Court in this case. Firstly, the court dealt with the question of FIR. It said that if an FIR has been lodged in Kolkata, then there are other remedies that could be resorted to under the Code of Criminal Procedure 1973, such as seeking quashment under Section 482. And directly coming to the Supreme Court is misconceived. The second observation of the Supreme Court was that the open court proceedings ensure that information regarding judicial process is available in public domain and subject to public scrutiny as the citizens have a right to know about what transpires in the course of judicial proceedings. Thus, here the Supreme Court talked about the right of the citizens to know about what is taking place in the courts. The third observation of the court was that the exceptions to open court proceedings are matters that involve right to privacy of an individual and fair trial. These issues involve cases such as sexual assault or matrimonial matters where privacy is of paramount importance, but apart from it, public scrutiny of the court process remains a vital principle for the functioning of democracy. These were the words of the court. Fourthly, the Supreme Court cited the case of Express Newspaper versus Union of India 1959 SCR 12. This case explained the mandate of Article 19(1)(a) of the Constitution of India that talks about right to freedom of speech and expression. According to this case, freedom of press is of two types. The first type is freedom from. What is freedom from? A press should be free from compulsions from whatever source, be it governmental or social or external or internal. The second type of freedom, according to the court, was freedom for. What is freedom for? A free press is free for the expression of opinion in all its phases. It is free for the achievement of those goals of press service on which its own ideals and the requirements of the community combine. Thus, there must be freedom for as well. The freedom for expression of opinion. Now let us come to the fifth observation of the court. Internet has refashioned in today's era and it has revolutionized the means through which information is relayed. The court also acknowledged that the world is adopting to technology at a pace which is often difficult to catalogue, hence preventing new forms of media from reporting on the courts would not be prudent. The court cited the example of England wherein the British court had observed that media may report on court proceedings using text-based communications like Twitter without making an application to the court. Various other case laws were also cited by the court to explain that the courts too must become tech-savvy and accept the new reality. Interestingly, it was also observed that our public constitutional institutions must find better responses to problems than to complain. The sixth point that I wish to make is that though the oral remarks made by the Madras High Court have been impugned by the Election Commission, but the Madras High Court had not been impleaded as a party to the proceedings. Thus, no opportunity of hearing was given to Madras High Court. Hence, the court noted that it would be unable to comment on the remarks that were made by the Madras High Court. It also observed that unless proceedings and its archival becomes a reality, the absence of records of oral proceedings would continue to bedevil the system. Some other interesting remarks were also made by the court that explained the working of the judiciary in general. I quote, "The manner in which judicial proceedings are conducted, especially in our superior courts, is unique to each judge and holds great weight in the dispensation of justice. The issues raised or comments made by the bench during an oral hearing provide clarity not just to the judges who adjudicate upon the matter, but also allow the lawyers to develop their arguments with a sense of creativity founded on a spontaneity of thought. Many a times, judges play the role of a devil's advocate with the counsel to solicit responses. These aid in a holistic understanding of the case and test the strength of the arguments advanced before them. That is where the real art of advocacy comes to play. The order or judgment of the court must indicate a process of reflection and of the application of mind of the judge to the submissions of opposing parties. The court ends. In this regard, the court cautioned that the judges must exercise judicial restraint before using strong and scathing language to criticize any individual or institution. The case of A.M. Mathur versus Pramod Kumar Gupta 1992 SCC 533 was cited, wherein it was observed that respect to those who come before the court as well to the other coordinate branches of the state, the executive and the legislature must be maintained, and derogatory remarks ought not to be made against persons or authorities whose conduct comes into consideration unless it is absolutely necessary for the decision of the case to anima advert on their conduct. According to the Supreme Court, the remarks of the High Court were harsh and the metaphor used by them was inappropriate, if at all those were the remarks of the Madras High Court. Despite these observations, the court stated that since those purported remarks were anyways not part of the record, therefore there is no question of expunging them. Thus, the petition filed by the Election Commission was disposed of on these terms that we just discussed. Basically, no relief was granted to the Election Commission. So what are my concluding remarks? I feel that in the present case, one constitutional body, that is EC, approached another constitutional body, that is the Supreme Court, to seek relief against the purported oral remarks made by another constitutional body, that is the Madras High Court. And none of these reliefs sought by the Election Commission seems to have been granted by the court. I think that the EC has a very onerous task at hand, that is to conduct elections of the entire India. What the citizens of India want to talk about should be left to them. What the judges want to talk about should be left to them. Though it was a delight to read this judgment by the Supreme Court, yet as the court said, I sincerely hope that our public constitutional institutions must find better responses than to complain. This applies to all the other constitutional bodies as well. With these remarks, I will end this show. If there are any comments, feel free to post them in the comments section. I would be glad to answer them. Thank you for listening. Please do not forget to like and subscribe us. See you next time. Till then, stay tuned.